There's growing concern among experts as to how the complex medical evidence was presented to the jury in the Lucy Letby trial. Now, whilst none of those experts have commented on the guilt or otherwise of Lucy Letby, it does raise a serious concern, because if we're going to punish somebody for a very serious crime, then we'd better be right about it. And that's the very reason we abolished the death penalty in 1965, because too many cases came to appeal and then realised that the jury had got it wrong and even courts had got it wrong, and ultimately it was obviously too late. Now, this video is not to say in the slightest that this is wrong, but it's just to emphasize that there is a possibility. There is always a possibility, because there have been lots of cases where people have been found to have been wrongly convicted and not before spending decades in prison. I've spoke about some of those in previous cases. So in this video, I'm just going to go through what some of these experts are saying. And it goes without saying, this video is not in any way intended to upset or insult anybody that's had any involvement with the case, directly or indirectly. But the expert evidence that these experts speak of is of paramount importance, because if a jury is to decide someone's guilt on that evidence, then it needs to be presented absolutely properly, because the jury can't otherwise understand it. Now, this was a very long trial with over 100 days of expert medical evidence, so let's take a look at what we're talking about here. This is from the BBC's File on 4 on the expert witnesses that have spoken to the BBC, and some of whom have written to the government as well, with concerns as to how this evidence was presented. This programme raises concerns about how the jury could get around the medical complexity of this evidence, and these experts have written and spoken to the BBC with various concerns, which I'll go through in this video, one of which was to do with insulin. Now, there is also a public inquiry ongoing at the moment, but that is not into the guilt or otherwise of Lucy Letby, but rather how she was able to do these acts, which obviously led to what happened. And many people have had various comments on that. I'll say no more about that for the moment. But suffice to say, there was 100 days, more than 100 days of complex evidence in the first trial that ended in August 2023. And of course, she was found guilty, and she's now serving 15 whole life terms. But some of this evidence here, and Mark MacDonald, one of new counsel for Lucy Letby, has told the BBC that he plans to take this case to the Criminal Cases Review Commission. And you might remember I mentioned Andy Malkinson before, who also had a case go to the CCRC and was found actually not to have been guilty, but not before having spent 17 years in prison for a crime that he did not commit. So these cases can be wrong from the outset. Not to say this one is, but it's just some cases are. And so this is why it's important to discuss these things. Now, as to the insulin evidence, she was found guilty of murdering 2 babies by adding insulin to intravenous feed bags. Now, the prosecution in these cases said that these were doing well before she attacked them, and that it was suspicious that she later went on to search for them on Facebook. Now, many people search for many people on Facebook. That may or may not be what they say it is. It's just that they say it was suspicious, and it formed part of the prosecution case against her. Prosecution alleged that it would have only taken a few drops to poison each baby. But the BBC programme File on 4 spoken to a team of mechanical and chemical engineers who disagree. They say that their calculations say that it would have taken very much more, calculated to be as roughly 20 to 80 times more for the same effect. And so there was no evidence at the trial to suggest that significant quantities of insulin had gone missing on the ward. And obviously, as a chemical, it would be carefully controlled and so on. Also speaking to the programme, other experts expressed their concerns about the use of the same blood test at the trial. Some of them saying that a single test might produce misleading results, and the error rate being 1 in 200. And a second confirmatory test was absolutely vital to be certain of something. But in this case, no second test was carried out. The prosecution said that one test was sufficient, and some experts say that the tests are so good that relying on one is sufficient. and the hospital didn't do further tests after because both babies soon recovered. But again, with the certainty required, one might reasonably say that they should have done a second test if they're going to rely on that by way of a criminal prosecution. But this is what was presented to the jury. Then, furthermore, talking about the X-ray and another baby's collapse, and key to this case was an X-ray, and it was referred to repeatedly during the trial, and in pre-trial reports, 2 prosecution witnesses showed that it showed a swollen stomach, which was most likely due to deliberate pumping of air into a feeding tube. However, a neonatologist, Dr. Michael Hall, who wasn't called to give evidence but has spoken publicly about these concerns, written to the chair of the public inquiry and told the BBC there are a number of possible explanations for there being gas there. Was consulted by the defence but never called to give evidence. Now, I can't speak for the defence team because I obviously didn't hear all the case and so on. Maybe it was felt that it wasn't necessary, but he said that it was likely to have been caused by the respiratory support that the baby was receiving, and the X-ray suggested that there was a bowel obstruction. Letby was not working on the day that the X-ray was taken and had not been on shift since before the baby was born. Information the jury heard in the first trial. Ben Myers, counsel at the original trial, highlighted these details in closing arguments, and in summing up, the judge made clear to the jury that this X-ray had been taken the day before the collapse, though didn't remind them that Letby hadn't been on shift. At appeal, the prosecution said that she could have visited the hospital while off shift, but didn't put any evidence forward that she was there. Now again, this was dismissed by the Court of Appeal, but looking at this both ways, because even the Court of Appeal can get it wrong sometimes, and when cases go through the CCRC and come back, and then actually it can change things around. Lots of people have raised these speculations. So this is all this is at the moment, speculation. Now, I will say at this point that a lot of people have said that it is poor taste to make any such speculation and discuss these things. But I would argue, as an advocate, by the way, I will often argue different sides, whether I agree with that side or not. So very often I will hear an argument put forward. I may not agree with that position, but I will very often argue for that position, because who else will they have to argue for them? And that is obtaining the right balance, because I firmly believe that both sides should be properly, fully, fiercely argued in order for a fair outcome. And so I'll very often argue and advocate for these decisions. So I will say that whilst a lot of people, I understand, don't like there to be discussion and argument over these points, I do think it's necessary, because if this was one of these cases where there's just been a catalogue of things that have led to one outcome, and in fact there is something that could indicate that in fact she didn't do these things and she wasn't responsible for those, then how else will we find out other than this discussion, and other than as her current legal team taking the case to the CCRC. And it is the case that we've had plenty of people in history who've spent a long time in prison for things that they didn't do. And so that, I feel, is necessary. And it is necessary for the interest of justice to continue the discussion. Although the law does have a finality, the law does like a certainty and finality to these things. Once somebody is found guilty, that's it. As far as the law is concerned, they are guilty unless and until the reverse is proven. But this is either one of the most gravest crimes of all time, the most gravest crime spree of all time, or it is one of the most grave miscarriages of justice of all time. And it really is that severe. It really is one extreme or the other. But coming back to the X-ray here, it says the BBC has also spoken to 5 senior clinicians who reviewed the medical notes made public at trial. Although only one had access to the complete medical history, they all noted that the baby was at high risk and should have been in a higher level unit. A retired professor of neonatology, Professor Colin Morley from the University of Cambridge, told File 4 that he was very confident that the baby died of natural causes. So we have a retired professor of the University of Cambridge in the study of neonatology saying that he's very confident that this baby died of natural causes. Now, again, on behalf of Professor Morley, I will say that that is a professional view that he's putting forward. It is not with the intent of upsetting anybody. It is purely for the intent of getting to the truth and providing his expert opinion on the evidence that he's seen. Far more expert than I will ever be, and it's experts such as Professor Morley that we should rely on, and ultimately should be relied on in trials and otherwise. At the trial, the X-ray was not the only evidence used to convict Letby on this charge. The prosecution argued that text messages showed that she was desperate to get into the room where this baby was being treated, even though she wasn't the designated nurse. Another nurse said that she found Letby standing over the cot when he collapsed. After he died, Letby again searched for the parents on Facebook. So this is a series and a catalogue of incidents that have all been put together to say that she must be responsible. Now, I confess to not having seen all of the evidence, of course. Certainly wasn't there for the over 100 days worth of evidence that was heard. But you can see how there is an alternative to this catalogue of events, this sequence of events. You can see that there is an alternative explanation. She wasn't the designated nurse. Doesn't mean that she didn't just want to help. And maybe that was the real cause. Maybe that was the real cause of her wanting to be in the room, because she wanted to help. The notes, the mind map notes, as it's been referred to, suggest that she felt she wasn't good enough. They've been used by the prosecution as evidence of confessions to these crimes. But another take on those notes could be that she didn't feel good enough at her job and she was trying to prove herself. Maybe that's one reason that she was there. Now, all we're looking for in a criminal trial is a reasonable doubt. For the avoidance of doubt, the jury did not find so, and the Court of Appeal did not find the ground of appeal. So this is not the case here as we stand. But in criminal cases, all we are looking for is a reasonable doubt that this happened the way that the prosecution said it did. In addition, searching for somebody on Facebook. Again, there could be an alternative explanation. I'm just putting this out there. You might call it devil's advocate. I often will put the opposite view and an alternative way of looking at it, because I challenge the way someone will think of it. You could do this with any possible case. You could take a case that has a polarizing views, such as Shamima Begum and the removal of her citizenship. You could look at this both ways. You could, on the one hand, say, well, absolutely, the security services have decided that she is a risk, and that's absolutely right. She should be denied citizenship, and that's the end of it. And that's what the courts have decided so far, that the process followed was lawful, and etc. The reverse argument to that, and again, I'm not telling you one way or another what to think, but the reverse argument to all of that is that actually she was so young at the time, she was manipulated, and therefore she didn't really know what she was doing, and therefore it's unfair to her in that she's now lost her citizenship, she's elsewhere, she can't come back here, her life is destroyed as she knew it, and so on. And again, flipping back to the other side, people will say she made that choice. She made the choice to go ahead. She was old enough to make that choice. You know, we trust people of a certain age. We call it Gillick competent to make decisions for themselves. If a child is old enough to make a decision for their own medical needs and so on, they are Gillick competent. And so they are old enough to make those choices. On the flip side, once again, the family courts make decisions up until and including when someone is 16 years old. The family courts, for example, make live with orders and arrangement orders up until the child is 16. The court will not make an order beyond 16. 16 is the age at which the courts believe the child can decide where they live, with whom they live, and so on. And so there's always, you can flip back and forth between these arguments. There are always different ways of looking at it. There was another section the BBC programme looked at, which was to do with liver damage. One baby of triplet brothers, born in good condition, was stable. And at the first trial, the jury were told that there was a remarkable deterioration and later died. The pathologist for the prosecution reviewed the case, said he believed that he'd suffered an impact injury to the liver akin to a road traffic collision. There was other evidence used to convict her, and she objected to the baby being moved to another area before being closely monitored. She was accused of falsifying medical notes, and there was a rash, which prosecution experts say was consistent with air being injected into the veins. However, and so that's one argument, fairly compelling. However, a leading senior perinatal pathologist told File on 4 that she disagrees with the original post-mortem, that the liver injury and death were by natural causes. And this pathologist, who's asked not to be identified because of the controversial nature of the case, said that she's seen this kind of liver damage at least 3 times in her career, and each time were natural causes. So again, you've got 2 polar opposite accounts here. One which by itself, the evidence of the pathologist to say that it's an impact injury. She objected to the baby being moved. She was accused of falsifying records, and all sorts of other evidence, such as which was consistent with air being injected and so on, all of which makes for a very compelling case against Lucy Letby. However, we now have senior, and these are not people without experience and expertise. These are leading experts, pathologists, saying that they disagree with that, saying that they've seen it a number of times before. So there again, the possibility of a reasonable doubt to say that it could have been any other number of causes, which was a natural cause, and thus not what the prosecution said it was. Now, just to reiterate that none of these experts that have spoken to File on 4 have made any evaluation about guilt or otherwise, neither am I doing so. What I'm doing here on my channel here to help you understand law is to really get across to you the careful, delicate balance of guilt or not guilty, and the balance that we have to present this evidence. And it very much is the case that a trial can be presented in such a way that you are absolutely convinced that the prosecution is right. And ideally, when the defense presents a case, you should be equally convinced that it's not right and that they're not guilty and that there is reasonable doubt. And that's where the balance begins, and that's where the jury needs then to begin and decide what their verdict is. And now, obviously, just to be clear, the jury's made that decision. The appeal thus far has dismissed permission to appeal on all grounds, rejecting the argument that this expert prosecution evidence was flawed in any way. And so now the current legal team is looking at putting something together for the CCRC. But I hope this somehow gives a deeper understanding of the kinds of concerns that these experts have with this evidence. Now, of course, this is a few minutes, 17 minutes at the time of recording overview of this case, but there were hundreds of days of evidence, so it's impossible to get across to you the complexity of this evidence and what they had to wrangle with. But I hope that's given some idea as to what these experts are concerned with and what they're considering and what they're talking about here. So if you find this useful, please do subscribe to the channel. If you are affected by this in any way, do reach out for support. There is plenty of support avenues available, such as the BBC Action Line referenced in the article that I've just mentioned on here, which I'll link in the description below. So for now, thank you for watching, and I'll see you next time.